So, what happens in a modern view? In modern view, the justice which was actually told to us through a system called as morals continue to remain with us, but now it has taken up a garb of a law. So, natural justice continue to remain with us, but in the form of legal rules, and these legal rules provide us justice. So, whenever a legal rule ensures a justice, it becomes legal justice, and that is what the modern view of justice. So, it is not a justice, a mere justice, it is a justice dispensed accordance with the legal rules. So, therefore, in the modern concept of justice, there are two parties, one is the right holder, another is a duty bearer. So, in the modern view of justice, there are 5 important components or characteristics. The first and very important characteristic of justice is it is secular in nature. So, religion has got nothing to do with it. Second one is the uniformity in justice, because the law prescribes justice and law ensures justice. Third, providing only the right is not enough, we need to have a remedy for that also. So, that is the third important component, that every right that is prescribed by a law, they provide remedy for it. The remedy can be of redressal of violated right, or it can be compensation for violating of a right. Then the fourth one is that the making of a law, enforcement of justice is going to be a prerogative of the state. The state is going to look after dispensation of justice. And the last one, the benefits, the punishments would be based upon the deeds of each person only, and no other considerations should be taken into consideration. So, to make a final distinction between traditional and the modern view, traditional view is connected with religion, and it is giving each his due. Justice is a virtue connected with the religion, but whereas in the modern view the 5 components are important. So, there is dispensation based upon the act of the person, there is recognition of a right, there is existence of a law, and then there is a remedy to enforce the violated right. So, let us move on from the traditional and modern view understanding of justice to effect of this modern view on the system. So, here the effect is that the state is under the duty not only to make a law, it is under the duty to establish an effective mechanism to enforce those rights. So, that is the most important impact of the modern view. The modern view led us to believe that ubi jus ibi remedium, where there is a right, there has to be a remedy. A right without remedy, it is like an illusory right which has got no existence. So, the impact of modern view is establishment of an elaborate mechanism for enforcement of justice. So, under the modern view, the state is under different kinds of obligations. The obligations goes as follows. State must ensure justifiable and fair equitable outcome of any act of a person, and to ensure such outcome they have to have a mechanism. This is going to be the second obligation, to build up a mechanism for justice delivery. Then after establishing mechanism, there has to be an effective and efficient judiciary to function and deliver the justice. Then along with the delivery of justice, there has to be a mechanism to make the law that facilitate access to justice, and then state also should provide additional kind of justices which I am going to deal in the nearby slides. So, coming to next part of the discussion, that is access to justice. So, what we have seen now is that there is a need for justice dispensation by the state, that is the obligation created by the modern view, and one of the important requirement under the modern view is access to justice. So, now question is, what is access to justice? According to the jurist Upendra Bakshi, access to justice is ability of a person to participate in judicial process. The question is whether that is actual definition or whether that is been, if that is a definition, whether that is been ensured by the state. So, traditionally we look at just access to justice as providing courts, sufficient number of courts, and then providing assistance to the needy people to approach the court. So, that becomes the major functions of access to justice traditionally. So, therefore, traditional view of access to justice would be court, establishment of a court to dispense the justice, then providing access to such courts, and in case of difficulties providing legal assistance to such needy persons. So, if these three activities are performed, then the justice is ensured. This is what a narrow look at access part. But if you look at the access to justice, practically there are series of problems which a person faces. So, I have just made a list of the 6 problems which a person may face while accessing justice, but this list is not exhaustive, this is mere an illustrative list. First is economic capacity or incapacity. So, when a person is economically weak, he may not be able to access justice because justice do not come free of cost. You have to make court fees as a payment, and then also you have to hire a service of an advocate. That is the first hindrance. Second one is procedure of justice. The Indian courts follow a justice delivery system which the procedure is cumbersome and the delay would be unimaginable, and further it is a lot of time consumption is involved in this process. So, this time consumption is going to be the second biggest hurdle which a litigant has to cross over. Third one would be complex procedure. The complex procedure makes a people or the litigant not to follow the proceedings before the court. So, he would be at loss. As a result of that, he would be completely dependent upon the professionals who are assisting the parties to rely on them to provide justice. Then comes the legal representation. So, the legal representation is another problem which the needy persons face, as the legal representation comes with a cost. Then comes the important aspect of geographical factors. Courts are established at the headquarters, and a person living in a remote place, Mufusili areas, has to travel all the way to the headquarters to fight the case. So, if you keep aside the litigation cost, that is court fees and fees to the advocates and additional fees, that is additional expenditure that is involved with other connected matters, the travelling itself would be another major expenses which litigant has to undertake. Then comes the inadequate number of courts. As the population is increasing, correspondingly there is no increase of the courts. So, keeping these problems in mind, there has been continuous attempt made by the jurist to come up with a new method, a new approach to provide meaningful access to justice. So, I have classified these 3 processes into 3 waves of reforms. The first wave of reform was initiated by Cappelletti and Garth. These jurists came up with the idea of providing legal aid. Now, legal aid is nothing but legal assistance. Then came the second wave, where the second wave was marked with the system of a class action. Now, class action is where a person is not in a position to go to court and fight a case, a group of persons who are not in a position to fight a case, somebody else would fight for them as a class. So, this class action, to quote few examples, public interest litigation is the best example for this class actions. Followed by, we have a provision in a civil procedure code of representative suits, that is also a good example of class action. Then comes a very important and the modern wave, that is the third wave, where the jurists, the legal systems, legislatures, everybody is encouraging the parties to go for ADRS, that is alternative dispute resolution systems. So, court should not be considered as the sole dispute resolution authority. The parties can take on themselves the burden of resolving a dispute by adopting negotiation, mediation, conciliation, or even arbitration as alternative process for resolution of dispute. So, therefore, the human rights movement of United Nations has actually expanded the concept of access to justice to the present date. So, earlier traditionally we looked at access to justice as providing legal assistance, but in the modern view the access to justice would be much more than merely providing assistance. So, the